started. Now that we have talked about the history and the origins of intellectual property, and you know a little bit about what intellectual property is, what it consists of, and you know the history of intellectual property, what I wanted to do is sort of dive right into patents, copyrights, and trademarks. I'd like to cover the patent material in the next 3 lectures, and that would include today's lecture all the way up through putting together our own preliminary patent application. We have a device to reverse engineer that I'm going to use, so I'd like to finish that stuff up by next Friday if possible. So I'd like to maybe pick up the pace a little bit. It's still going to be no heavy lifting, but next week things are going to get, I think, a little bit more intense, and I'll have some readings for you. Anyhow, with that, let me just sort of dive into patents, copyrights, and trademarks, and in no particular order, we're going to start with patents. What is a patent? A patent is a government license that gives the holder exclusive rights to a process, design, or new invention for a designated period of time. The purpose of a patent is to exclude others from making, using, or selling the invention. Applications for patents are usually handled by a government agency, and in the United States, that agency is the United States Patent and Trademark Office. The purpose of a patent, as we've discussed briefly, is by granting the right to produce a new product without fear of competition. Patents provide incentives for companies or individuals to continue developing innovative new products or services. In essence, patents and other forms of intellectual property grant to the owner a temporary monopoly, which provides exclusive ownership rights over a form of intellectual property. For example, pharmaceutical companies invest large sums of money on research and development, and patents are essential to earning a profit. By protecting such intellectual property, patents provide companies with the security from competition that provides incentive for further investment. I don't know if you saw recently, GlaxoSmithKline has come up with a genetically engineered protein which has the incidental benefit of prohibiting the transmission or the production of acquired immune deficiency AIDS in the human body. It has tremendous potential for human application. The investment that GlaxoSmithKline put in that particular drug is enormous. And in order to incentivize companies like Glaxo and the other, there's a number of big pharmaceutical companies here in East Cambridge, in order to incentivize them to produce these inventions that benefit all of us, we as a society have decided to grant them certain monopolies for limited periods of time so that they can recoup their investment and hopefully make a fair profit. Yes, sir?
So how does it balance between, so you have like the USPTO, which is going to grant them like an exclusive right for like 20 years, but then you also have like the FDA that has their own restrictions on, like for GlaxoSmithKline, like if you're going to put something in the human body, it can take like 15 years in order to get approval to actually do that.
That's
so
right.
That means that if they patent it as soon as it is applicable, then they basically, by the time they're approved to actually sell it, they only have 5 years.
Yeah, that's where this AIA agreement has caused some problems, and we're going to be getting into it. And I don't want to put off the answer to your question, but I want to put off the answer to your question because we're going to get into that. There are, in a case like that, for instance, those patents can go on for much longer than the normal period of time. We'll be getting into some Supreme Court cases that apply the law in that area, at least as it pertains to licensees. Because how would you like to license that patent, pay an enormous amount of money to SmithKline, and then suddenly the clock times out on you? So there's a whole body of law on that I'm going to get into. But just sticking with some of the generalities, the purpose of a the sources of patent law. Okay, we already talked about the United States Constitution. That's the very basics, Article 1, Section 8. And then as far as we here in the United States are concerned, there's the Patent Act of 1790, the Patent Act of 1793, the Patent Act of 1836, the Sherman Antitrust Act, the Patent Act of 1952, which was, for all intents and purposes, the statute that applied and controlled patent law in the United States, right up until 2013, when the 2011 America Invents Act went into effect. That is now a significant revision in patent law in the United States, and in many ways has changed the Patent Act of 1952 in important respects. And then the final source of patent law are our Supreme Court decisions. Our Supreme Court has stayed out of the patent business almost entirely from the day that the Supreme Court was created in 1790 right up until, well, about the year 2000. But in the last 10 years, the Supreme Court has really become a very activist court when it comes to the granting of patent licenses. And we'll talk about some of the important decisions. Part of that is a reflection of the political makeup of the court. Part of that is a reflection of how science is changing and evolving, and how inventions are coming on so quickly that sometimes the court has to jump in and deal with issues that are novel, that are new, that weren't anticipated when Congress sat down and wrote these statutes. But the Supreme Court gives very little deference these days to the United States Patent and Trademark Office, to the lower federal courts, or even to Congress. They've become kind of like the final word, and sometimes the inventors of the word on patent law, no pun intended. So just briefly, going back to 1790, again, it's important to understand the historical origins of patent law. But the Patent Act of 1790 was entitled An Act to Promote the Progress of Useful Arts. Again, you see the recurring theme that goes back to the 1400s about benefiting society, the progression of knowledge, the dissemination of information. The statute was a short one, included only 7 sections. Similar to state statutes, as a matter of fact, Massachusetts had one of the very first patent statutes. This federal statute allowed the patentees to have a 14-year term of exclusive rights to their inventions. It was unsatisfactory to many inventors who wanted extended protection for their inventions. They argued that 14 years was not enough, given that it often took several years for their inventions to be commercialized. Which I think goes to your question. So this is not a new question. This is a question that has bothered inventors since 1790. Another important aspect of the act was that it did not allow foreigners to obtain patents in the United States. Remember what I talked about when it comes to developing countries. Sometimes it depends on what side of the dividing line of developed and undeveloped that you are. Back in 1790, the United States was in many ways a very backward place when it came to technology and innovation. And one of the ways that Congress decided to protect inventors in this country, in addition to paying them to steal other people's patents, was to make it impossible for others to get patents in the United States. That way, only United States companies and individuals in the United States receive that sort of protection. Again, it's a way of promoting the commercialization of ideas adopted and invented here in the United States. And, you know, if you look at the developing countries around the world, you'll find the same pattern. You go to a country that's just now codifying their patent law, you'll find that foreigners can't get patents in those countries. Why? Because as a developing nation, you have there's certain benefits to restricting or making a monopoly just for your inventors. Patent Act of 1793 had several important changes over the 1790 Act. It was notable for its definition of the subjects of patents, which remains unchanged, even in the AIA. That is, any new and useful art, machine, manufacture, or composition of matter, and any new and useful improvement on any art, machine, manufacture, or composition of matter. That's the definition you start with today when you file a patent application. And when that patent examiner looks at your application, they're going to that definition to decide whether or not your patent is going to be approved. It's a wonderful term, and that has been a definition, and that has been copied by countries all over the world because of the broad nature of the definition. In this particular act, the patent application process was much simpler than the prior act. People who sought patents only needed to petition the Secretary of State. And then it was the duty of the Secretary of State to require examination from the Attorney General. The examination process was greatly simplified by dropping the clause that patented inventions needed to be sufficiently useful and important. It was enough that the inventions were somehow useful, even if the usefulness was insignificant and not before known or used to be granted patents. A lot of federal judges that I appear from apparently have not familiarized themselves with the 1793 Act. They're still on the 1790 Act because oftentimes we'll run into a judge that will try to pass judgment on the utility or the usefulness or whether a patented device is worthwhile. Lots of judges think that, that's not really that useful or that important to society, so I'm going to deny it. But that sufficiently useful and important phrase was dropped from the patent law in 1790, but again, that's news to many federal judges, even some in this jurisdiction, and is one of the reasons why a lot of the district court decisions are reversed in the First Circuit. Moving on about 50 years, the next important act was the Patent Act of 1936. This was significant for 4 reasons. First, the act created the official patent office. We never had one before that time. Which was part of the Department of State, but now is under the Department of Commerce. The second reason that this act was important is because it prevented applications for already patented inventions by requiring information on newly granted patents to be made publicly accessible at libraries. Back in the 1700s, it wasn't possible to know whether or not your invention had been invented by anybody. Unless the patent examiner, or at that time, the Secretary of State, happened to know that it had been invented by someone. In this act, Congress finally made it a requirement that all patents become public knowledge, and they're available in public libraries. You can actually, well, of course now we have online, you can do a patent search literally online. And that's because the Act of 1836 requires all patents to be published. That way, when an inventor has an application to make, they can find out whether somebody else somewhere has already invented or patented this. And it cut down significantly on duplication or the patenting of things that had already been patented. Third, the Act resolved a longstanding dissatisfaction on patent terms by allowing for the first time a possible extension of 7 years of protection in addition to the original 14-year term. With permission of the Commission of Patent, upon appropriate reasons, patentees could appeal to have their patents extended. And that's true today, although that has also changed, but that's the first time that the Congress had ever dealt with the commercial realities of patents being sometimes overcome by the commercial realities. Sometimes it takes a long time to get a product to market. We weren't dealing with biological agents back then, but even then, manufacturing a particular auto cannon was sometimes took a long time to get to market, And so since that was a problem, Congress finally addressed it in the 1836 Act, and that's one of the important innovations of why this act is important, and why we're talking about it still today. And finally, this act removed the U.S. nationality and residency requirements, making it possible for U.S. Non-U.S. citizens and foreigners to get patents in this country. Back in 1836, commerce was becoming more internationalized, and Congress wanted our patents here in the United States to be given full faith and credit by governments, other governments, and so as a quid pro quo for that, in the 1836 Act, Congress finally incorporated the part where foreigners could obtain patents here. Now, one act that's not really thought of too much as related to patent law, but which I think is very important to patent law, is the Sherman Antitrust Act. After the Depression, in the latter part of the early part of the 1900s, there was a movement in this country which strongly disfavored patents because they were seen as creating these enormous disparities in wealth caused by the monopolies. You've heard of robber barons and other things to describe this class that was created as a result of the Industrial Revolution. And the disparity of wealth which resulted in the Depression of the early 1900s really created a very hostile attitude in this country politically and socially towards patents and those who held patents. And so this attitude sort of culminated in the creation and passage of the Sherman Antitrust Act. During the Depression, many opposed patents, and this is depicted in the tendency of the courts at that time to invalidate them. The conclusion of the Depression also ended the negative attitudes towards patents. However, the patent law underwent opposition again in the Great Depression. It seems that this is sort of a recurring cycle, at least in terms of looking at patents from a social standpoint. Every time that in this country there is enormous wealth created and concentrated in a particular class, back then the industrial class, patents become disfavored. Again, it's an echo of that balance that we've been talking about since the very beginning. What's the benefit to society, and on the other side, what's the benefit to the creator? It's always a tension that Congress has been wrestling with, and as a society will probably continue to wrestle with, because the interests of society are as important as creating wealth and incentives for individuals who do the inventing and the creating. Finally, we get to the Patent Act of 1952, which is really the basic architecture of modern patent law here in the United States. And this amendment to the Patent Act of 1836, under this amendment, an inventor only had to describe not only his invention, but also the basis for its infringement. This was a novel, new sort of wrinkle in patent law. It's becoming more refined, more detailed in the way that inventors have to describe what it is that they are trying to protect. This act also provided that an invention needed to be new and useful as well as non-obvious to be granted a patent. This amendment, which required patents to be non-obvious, was implemented to keep individuals from taking ownership or taking away from the base pool of knowledge in a particular field. You understand what that means? What they're talking about is they just don't want to hand out patents to everyone if it doesn't represent a new idea or an innovation or some sort of application of creative genius. There are a lot of things that are simply obvious that don't deserve patent protection. And we'll get into obviousness and non-obviousness and novelty in a moment. So modern patent law in the 1980s and 90s, the atmosphere once again became very pro-patent. The patent was seen as not only a business need, but also as a means to protect investors. Patents became important once again, and they began to signify the importance of technology, invention, and discovery in the United States. In 1982, the Court of Customs and Patent Appeals was abolished, and patent cases were heard in a newly established Court of Appeals for the Federal Circuit. Basically, what Congress did is they created a court that was going to hear nothing but patent cases from all over the country. And the Court of Appeals for the Federal Circuit observed patents favorably and also started to provide more protection to their owners. It was decided that we really needed a court that specialized exclusively in patents, and that was this court. And this court was really the sole arbiter for judicial decisions on patents until, as I said, the United States Supreme Court decided to get into the act. And the U.S. Supreme Court now, today, gives this court very little deference. But for 30 years, it was the court that created all of the patent law in the United States and resolved all of the disputes. Finally, in 2011, as I mentioned, the American Invent Act was enacted. That is the most significant change to the U.S. patent system since 1952. After decades of debate in the U.S. comparing and contrasting the pros and cons of first to invent versus first to file, the AIA switched systems in the United States from first to invent to first inventor to file. So as of March, I think, 13th, 2013, when this law went into effect, approximately 200 years of patent law was completely changed. We went from a first to invent to a first inventor to file country, much like the rest of the world. In fact, the U.S. was the last remaining major country still using a first to invent system. And the AIA reforms eliminated interference proceedings and developed post-grant opposition. Its central provisions went into effect on March 16th, 2013 for patent applications filed on or after that date. It is the most important act to come out of Congress since 1952. As I said, it's absolutely changed the playing field for inventors out there. There's a whole new series of things that inventors have to consider concerning first inventor to file. Generally speaking, what rights do patent owners have? A patent owner has the right to decide who may or may not use the patented invention for a period during which it is protected. Patent owners may give permission or license other parties to use their inventions on mutually agreeable terms, and owners of patents may also sell or license their invention to someone else, who then becomes the new owner of the patent. Yes?
Can you share a patent? Could people file for a patent?
The answer is they would have to. The answer is yes. But you have to file jointly. Sometimes they file limited partnerships or ways of dealing with that because, of course, there are commercial things that you have to consider. You'll be amazed at how quickly your best friend is no longer your best friend when the profits start rolling in. So yeah, you can form people. More than one person can be the owner of a patent, or a patent can be owned jointly. Or what happens more often is that they form associations or groups for the purposes of owning a patent. A patent can be owned by anybody or anything, basically. It can, it's like a house or it's like a chair. Anything that can own a chair can own a patent. There's no difference between an intellectual property right and the right to own something that's tangible that you can drive or live in or use. So it's just like anything else.
If you can sell your patent off to someone else, say you have like a family business, could you just keep the patent like in the family by selling it down generations? Or?
Sure, but of course you run up to you run up against the time limitation. The duration of patents is 20 or 14 years, depending upon the type of So you'd have to have very short generations, and my family has longer generations, but you can pass it on. You can sell it to your brother or sister. You can give it away. Anything that you can do with an object that you own, you can do with a patent. And one of the things that you need to be thinking about with intellectual property, and that's the whole reason we discuss all this, is this whole area of law and invention that involves ideas of the mind that have just been, that are just in a fixed or tangible form. As long as it's in a fixed or tangible form, it's the same as a box, a microwave, a desk, a light, a car, a house. Intellectual property is a real thing, even though sometimes it's hard to put your finger on it. The lifespan of a patent, starting to drill down to where I think a lot of you are thinking. Generally, the U.S. Patent and Trademark Office grants utility patents and plant patents for 20 years and design patents for 14 years. There are exceptions, we'll be getting into that, and there are ways patents can be, the lifespan of a patent can be extended. Once a patent expires, protection ends and the invention enters the public domain. This is also known as becoming off patent, meaning that the owner no longer holds exclusive rights to the invention. It becomes available for commercial exploitation by anybody. And there are people, businesses, who literally sit there waiting, counting the days for patents to expire on various processes and inventions so that they can take advantage of them and improve them themselves. Yes, sir?
So when you say commercial exploitation, does that mean that if somebody develops a process, I like the process, and I somehow have 20 years of patience. I have 20 years of patience and I build the device to then do the exact same thing. That as long as I don't use that device to commercially exploit that technology, then I'm fine. If I have it and built it, then I'm fine. But as soon as 20 days is up, then I can start selling it using the process.
As soon as 20 years is up, it's in the public domain. So this iPhone that I invented, actually this is a droid that I invented. I own the patent on this for 20 years. Assuming it's not extended for any reason, and the patent ends, this becomes the public domain, and anybody can patent it. Can't patent it because the patent had expired and it's no longer new or novel. But anybody can build one exactly like it and not bump up against your patent. Of course, there's probably not a lot of market for a 20-year-old droid. At least 20 years from now, I doubt there will be.
I think his question is basically, can you extend your patent life by not using it for the first 20 years? And the answer is no.
No. The clock starts ticking as soon as the patent is approved. So, yeah, it's tick-tock, tick-tock, tick-tock. Now, you can go back to the USPTO and you can ask for extensions of time, and the USPTO, under certain circumstances, can grant you extensions. And one of them is actually the process that you have to go through in order to get approval of a particular drug before it can be commercialized. So there are exceptions to it, but generally you got 14 or 20 years, and once the clock, a little timer goes off, it belongs to everybody.
Just on that timeline, you say 20 years. Is that from filing the provisional, or it's really from when the patent is issued?
Approval. When the USPTO patent examiner issues the patent.
Yeah.
Okay. So there's a process that they go through. There's an examination process. Sometimes the examination process can take years. But once the examination process is completed and the examiner has determined that you're entitled to a patent and they issue the patent, I think the clock actually starts ticking the day that it is published. So, and that's usually within days that of the patent being issued. So I could be wrong about that, but it's...
2 points is, one is, I wrote a paper in 1985 that I got the idea, I don't remember where, but it's quoted many times. It takes 20 years on average to bring a new material to market. And so there's this problem that in material science, all the work that, so just like drugs and stuff, it may be the regulatory stuff, but it's just the development to bring a new material to market. You end up losing your patent protection in the useful time period. Right?
Yeah, and you know, obviously, that's even more important nowadays, and with the AIA, with first inventor to file, that even becomes more difficult. You know, there's this, again, this tension going back to the 1790 Act about only wanting to award patents for things that are truly inventive and new and acts of genius. And so, to the extent that something is, you know, sort of not new, you might be just ahead of the rest of them, it's difficult for that type, to commercially exploit that type of an invention. So there's that, you know, you have all of these tensions that are lining up to make it difficult to be an inventor.
And not to slow you down too much, but the example I like to give of one of these things of a patent issued late, General Electric developed a high temperature alloy to go in not jet turbines, but in land-based turbines, called GTD 111. And then it was within the composition of the pre-existing patents, and everybody knew that. And so everybody started using this General Electric alloy. 18 years later, a General Electric heat treatment patent issued on this after 18 years of review. And everybody had designed this into all kinds of products, millions, hundreds of millions, if not $1 billion worth of products. And all of a sudden, General Electric said, oh, by the way, you now owe us royalties because the patent just issued. And everybody was shocked.
That's right. That's right. There's a lot of risk involved in the commercial exploitation of patents or the use of patented technology or nearly patented technology. You're right. And this first inventor to file thing is really something that is going to create a lot of benefits for some and a lot of problems for others. And you know, we've already talked about this. How does society benefit? You know, it creates monopolies. Yes, sir.
I kind of have a similar question.
Okay.
So I saw a lot of like patent pending.
Mm-hmm.
What's the difference between patent pending and actually we got a patent?
Patent pending is a notice to the public that you have applied for a patent and that your use of this technology is at your risk because like the General Electric, this patent may be approved, and in which case you are going to owe us royalties. So you need to take that into consideration when in your turbine, you know, building company, whether you want to avail yourself of that technology or whether you want to innovate. It might behoove you to call the patent pending inventor and try to work out something early than retroactively.
Another example that I know of is in the fast-moving field of personal computers. Okay, it turns out Bell Labs had a number of patents that they were developing, and they really weren't enforcing them. And it turns out that when they split off and became Lucent, the new person at Lucent decided we're going to start enforcing this, and so they hired a guy I know here at MIT whose job was basically to go out and purchase laptops and things, take them apart, figure out which hardware and which software was infringing Lucent technologies. He would write a report, give it to Lucent. Lucent's patent attorneys would go to some computer manufacturer and say, oh, by the way, we notice you're using our patents, and we think you should give us this amount of money. And there was never a lawsuit that came out of that. They just got a lot of money. Okay.
Well, because they had them dead to rights, and sometimes it's better to switch than fight, right? Yeah, absolutely. It's just like, you know, it's like any other item. It's no different than this eraser. As long as it's tangible, you own it, and others use it at their own risk. It's your property. All right. Briefly, three kinds of patents. There are utility patents, design patents, and plant patents. What's the difference between those three? Utility patents apply to new and useful processes, machines, manufacturers, compositions of matter, or any new and useful improvement in one of these. Traditionally, utility patents have been divided into three basic types: mechanical, electrical, and chemical. Pharmaceutical products are a special case of chemical patents. So can anybody give me an example of a utility patent?
New alloy.
Sure. New alloy, they're simpler, they're simple ones. One more example of a utility. Can you name me one product that represents a useful process, machine, manufacture, composition of matter, or a new and useful improvement in one of these?
LED light bulbs.
Sure. LED light bulbs. A great example. All right. That's a utility patent. Design patents. Design patents apply to new, original, and ornamental designs for an article of manufacture. Can anybody think of a design which might be in this class?
Geodesic dome.
Okay, never thought of that.
I don't know if anyone ever designed it. Buckminster Fuller should have gotten one, right?
He should have gotten one. I think that'd be in the public domain right now.
Yeah.
But design patents. How about ornamental designs? Oh, good.
I was just gonna say like the chairs.
You know that may actually that I think that probably does qualify. Sure. The design of a particular car or an emblem, a logo in some cases is patentable if it's not something that can be trademarked or copyrighted. So things that are related to design. And plant patents. Plant patents are granted to any person who has invented or discovered and asexually reproduced any distinct and new variety of plant, including cultivated, sprouts, mutants, hybrids, newly found seedlings, other than tuber propagated plant or a plant found in an uncultivated state. I have no idea what that last part. I think you have to know more about biology and agriculture than I do. I don't know what the difference between newfound seeds and tuber propagated plant or plant found in an uncultivated state. I guess it means just growing wild in the field, I guess. So obviously if you just find something growing wild in the field, you haven't developed it. It occurs naturally in nature, so that's not something that you could patent it. That's a discovery, but it's not patentable. You'd have to go into a laboratory and actually asexually reproduce some mutant variety of biology. That would be a plant patent.
What if you discover how to cultivate it though? So like huckleberries,
Well,
they are cultivated,
the
but
process. You could not patent the huckleberry, but you could theoretically patent the process for cultivating them. And how would we do that? When does he's sitting there having his coffee in the morning and he thinks of a unique way of cultivating huckleberries? Is that patentable? I see head shaking. You're right to shake your head. Why?
It's not tangible.
Exactly. When does it become patentable?
When you write it down.
When you can sit down and actually describe it on a piece of paper. In this particular case, a patent application. But yes, that's exactly right. All right, requirements for patent protection. To obtain patent protection for a particular form of intellectual property, its subject matter must be accepted as patentable. In the US and many other places, scientific theories, mathematical methods, plants or animal varieties, so long as they've not been asexually reproduced in some laboratory, discovery of natural substances and other things like that, are not considered intellectual property and are therefore not patentable. So if you want to know what is patentable, you go right to the Act. This is Section 101 of the 1952 Act, and this is the definition of what is patentable. We already went over this definition earlier, but I wanted to show it to you. Whoever invents or discovers any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvements thereon, may obtain a patent subject to the conditions and requirements of this title. That's the beginning of every patent application, every patent examination, and every patent that is issued. Breaking it down, there are basically 4 requirements. A patent must be statutory, that is, it must be provided for under the statute, it must be new, it must be useful, and it must be non-obvious. These are very important terms that we'll become more familiar with. These are the terms that courts, including the Supreme Court, have wrestled with, and inventors have wrestled with, but they're the basically the 4 most important terms when it comes to determining whether something is patentable.
Didn't you say earlier that, like, in the patent law of 1793, like, basically eliminated the need for it to be useful, or?
It eliminated the need. Usefulness is important, but how useful is no longer important. And there's a distinction. As I said, the federal judges sometimes look at this and they say, you didn't put very much work into this, and what use could it be? So long as it is of some use and meets the other requirements, then it meets the test. In 1790, it had to, there was a subjective element that it really had to, in some persons, usually in the Secretary of State's judgment, because that's who was issuing patents back then, had to be of certain significant utility. Significant is out now, and it just has to be useful in some way. All right, let's talk about the statutory requirement. Of the 4 requirements, this is the first. The U.S. patent statute states that processes, machines, articles of manufacture, and compositions of matter are patentable. That comes right out of the statute. It's not in the statute, it's not patentable. So this wording appears to cover almost every useful invention imaginable, and to a large extent, I guess this is true, although we'll study some cases where the court has said, no, this falls outside of the language that Congress came up with, which of course goes all the way back to the 1836 Act. Under the statute, the United States has one of the broadest standards of what is patentable in the entire world, and most inventors, including most of those in the software and computer fields, don't have to worry about whether their inventions are non-statutory, because they clearly fall within that definition. Examples of things that are non-statutory. There are certain inventions which are not patentable under the Patent Act. And here's some examples. Sometimes it's easier to find out what is patentable if you know what is not patentable. Data structures or programs per se. These are considered functional descriptive materials, which impart functionality when employed as a computer component, but are mere descriptive material when claimed standing alone. These items may be patentable when claimed in a different form to include computer-readable medium. Somebody here the other day was asking me about just adding a computer to something and whether or not that constitutes intellectual property. That's an example of something that is probably not patentable. Non-functional descriptive materials, such as music, literary works, and compilations, or mere arrangements of data, are not patentable, although they may be protected in other ways under copyright or trademark law. Electromagnetic signals, which are considered a form of energy, and as such are non-statutory natural phenomenon, which is why computer programs are patentable when embodied in something tangible, such as a computer-readable medium, but computer programs are not patentable when embodied in a computer-readable signal stream. In other words, a bunch of ones and zeros being transmitted electronically or by radio. It's not patentable. All of these items are considered indistinguishable from abstract ideas and laws of nature, and therefore not patentable. Once again, this is why we've spent so much time on the basics of this. As long as it's tangible, as long as it's in a fixed form, it's usually an intellectual property that can be patented or protected in some other way. Now, the second requirement is the newness requirement, or the novelty requirement. In order for an invention to be patentable, it must be new as defined under patent law. And this novelty requirement states that an invention cannot be patented if certain public disclosures of the invention have already been made. So if you have an idea, keep it to yourself. At the next convention of inventors, don't stand up there and say, gee, I've had a great idea. Because the disclosure of an idea sometimes destroys its novelty. The statute, which explains when a public disclosure has been made, is complicated and often requires a detailed analysis of the facts and the law. Take my word for it. The most important rule, however, is that an invention will not normally be patentable if the invention was known to the public before it was, quote, invented by the individual seeking patent protection. The invention was described in a publication more than 1 year to the filing date. That's why, one of the things first thing you do when you're a lawyer, or somebody comes in and says, I have an idea, I want to file a patent, you say, how long has it been since you had the idea or disclosed the idea to anybody? If the answer is 366 days, you're out of luck. You have 1 year to file the patent application. The invention was used publicly or offered for sale to the public more than 1 year prior to the filing date. Anything that you invent, if you want to protect it, don't disclose it, and if you disclose it, file the application for a patent within 1 year. And now, since March 16th, 2013, file it before anybody else files it. One of the most important lessons to learn from this requirement is that there is a 1 year period after the first public disclosure. This statutory bar is inflexible and inviolate, which means that an inventor who does not file for a patent protection within the 1 year grace period will lose all rights to obtain patent protection. You can still use it, you can still build it, you can still sell it, but so can everybody else. Although the United States grants 1 year grace period, most other countries don't grant the grace period. Therefore, it is always preferable to file a patent application before any public disclosure of the invention. If anybody comes into me, especially now under first inventor to file, I say you've got to file as soon as possible. You've got to start this. You've got to make a disclosure under first to file. And so what I tell them all to do is, if it's not ready to file a formal application, I tell them to file a preliminary application. That protects your rights under first inventor to file. And it's the type of disclosure which sort of fixes in time. And then, of course, you've got to file the application after that. It's important under first to file, even if you're not ready to go forward with a full-blown patent application, to file a preliminary patent application. Just finishing up with these four important elements. The usefulness requirement. Patent law specifies that subject matter must be useful. The term useful in this connotation refers to the condition that the subject matter has a useful purpose and also includes operativeness. That is, a device which will not operate to perform the intended purpose would not be called useful, and therefore would not be granted a patent. In most cases, the usefulness requirement is easily met in mechanical, computer, or electronic technologies. But if it don't work, it won't be patented.
So do I have to prove that it works?
You bet you do. You have to prove to the examiner's satisfaction that the design that you've come up with will perform the function which you claim it will perform. Remember that part, maybe some of you who have some passing familiarity with patent applications, there's this whole thing about claims which you have to make. And finally, the novelty or non-obviousness requirement. If an invention is not exactly the same as a prior product or process, then it is considered novel. new. However, in order for an invention to be patentable, it must not only be novel, it must also be non-obvious improvement. So changing the color of something or changing the material that something's made of does not render it novel, and that's not patentable. If you take somebody's patent and just change what it's made out of, it most likely is not patentable unless that material or superficial change has an impact on its function or utility. Continuing with novelty and non-obviousness, to determine whether a particular change or improvement is obvious is sometimes a difficult question. In order to make that determination, the examiner in the patent office will normally review previous patents to find those patents which are closest to the invention. And they'll literally sit down and examine different inventions and find out whether or not this really adds anything to the prior invention. If it doesn't add anything, it doesn't improve on it, if it doesn't significantly change it in some way, then it's not patentable because it's not novel, it's not new. If no patent contains all of the features, that is something that's patent prior to this one, the examiner will attempt to combine two or more minor patents and attempt to find all of the features in combination. If the examiner is successful in finding a combination, the examiner will generally reject the invention as not novel. But that's one of the ones you go and fight sometimes because examiners can be wrong. Combining one or more other devices that have been patented sometimes is not a fair way of examining an application, and so you hire a guy like me to go in there and fight the USPTO on that. And usually what you can do is you can show that what you have proposed is at least a significant improvement or step up on the older device, which makes it patentable because it's novel and useful. Some changes to known products which would not be patentable are the substitution of one material for another, which I already mentioned, changes in size, changes in color. Anyhow, I can see we'll run out of time. Next time we get together, we'll start talking about AIA and the first inventor to file. It has some really important applications and applicability to our preliminary patent application that we're going to work on. And that's where we'll pick up when I see you next Free Bagel Thursday. Thanks, guys. And if you don't